Who gets the house if there's no will? We'll get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Mohr, Realtor, life member of the Masters Club, and certified probate and trust specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary. I'm also a licensed California real estate broker, and I'm a registered and bonded California legal document assistant specializing in probate and trust work.
Now go ahead and like and subscribe, and if you've got a house to sell, we can help you avoid the cost and headache of probate and trust administration. Those services come with the listing at a phenomenal discount with no upfront fees, saving families thousands in costs. We can even help with the petition to determine succession to primary residence process. Our contact info is in the About section. Don't wait, reach out today. A parent passes away without a will. Now the family's asking, who gets the house? In California, there's a clear legal answer, but it's not always the one you would expect. Now I want to preempt this because we're a probate real estate channel, and a lot of people will say to me, oh, probate, that's when somebody passes away and there's no will. That is not true. Yeah, in fact, you said to me before, a will actually guarantees probate.
It does, yeah. It certainly can.
Yeah, it certainly can, right. I don't want to talk in absolutes, I suppose. But if there's a trust, then that's a great way to avoid probate. But if there's no trust, then yeah. So, Bill, what are we talking about here? What's the term called when determining who inherits a home?
You're under the probate code. There's something, and all states have this, but in California under the probate code, it's called intestate succession. And it's basically the laws of intestacy. And that's where if you pass away and you have no will and you got to go through probate, well, then the California law, the probate codes, they determine who gets what in a situation like that.
Now, who inherits the house in, I'm going to give you several situations here.
Sure.
Okay.
Sure.
Married with kids. So mom is alive, dad passes away. Who gets the house? Married with kids.
Sure, absolutely, and that's that happens a lot. Well, any what's called community property that the spouse owned with the deceased spouse, that goes to her, to him or her, the surviving spouse. But separate property, which is not community, if the surviving spouse and the deceased spouse had one child, then the surviving spouse is going to get half of the separate property, and the one child is going to get half of the separate property.
Oh.
Now, if the surviving spouse and the deceased spouse had more than one child, it's a little bit different. In that case, again, the surviving spouse gets all the community property. But as far as the separate property goes, the surviving spouse will get 1/3 of the separate property, and that other 2/3 will be divided equally among the surviving children. So that's how it goes when married with kids.
Gotcha. So does it matter how the house is titled, how it's held?
Actually, it does, and that's an excellent point. If the house is held in joint tenancy, then what I just said holds, because the deceased spouse is just removed by a simple affidavit recorded with the recorder. But if the home was held, for example, let's say the home was held in the deceased spouse's name as his sole and separate property, well, then the entire house is separate property, and it's going to go according to the separate property laws. There's also, spouses can hold property as husband and wife as community property. And if it's held that way, then the entire house is going to go over to the surviving spouse, and the kids don't get any of it because it was specifically held as community property. So you bring up a good point. How the husband and wife held title when one of them passes makes a difference on how it's going to go if the deceased spouse had no will. So good points. Yeah.
Got it. So let's just say they're married and no kids.
Mm-hmm. Married and no kids, the surviving spouse should end up with everything. How
about unmarried with kids?
Unmarried with kids. All right. I'm assuming in that situation, the unmarried is the surviving person, and his or her significant other is the deceased person.
Let's say in this particular case, the unmarried person passes away and they only had kids.
Oh,
No
I see.
spouse.
I see what you're saying. I'm sorry.
I didn't specify.
That's all right. That's right. The kids would get everything. They'd split it equally.
Okay.
That's how that would go.
So let's say an unmarried person passes away and there are no kids.
If an unmarried person passes away and has no kids, then what's going to happen is through the intestate succession laws, it's going to branch out through the family tree. What I mean by that is if that unmarried person with no kids has parents or parents that survived, it's all going to go to the parents. If he or she had no parents surviving, they'll look for brothers and sisters, and then it would go equally among the brothers and sisters. If they had, say, no brothers and sisters that survived, but nieces and nephews, it's going to go to them. And it branches like that.
Oh, before I get to my last one of that section there was one that you and I had looked into that we decided there was a lot going on because of so many heirs. It was a husband and wife. The husband passed away 30 years prior. She was a widow. She had no kids and she passed away. The family had let a good 15 years go on and didn't start the probate. So this lady had 11 siblings and she was quite elderly when she passed away. So we're talking all of her siblings the living ones were in their 90s. The deceased ones would have been all the way into 120s. They had children, they had grandchildren, they had great-grandchildren. They had the siblings had children who had already passed away as well. There were so many heirs. I stopped when I counted 70 because it was the family tree was going, brother, sister, brother, sister, brother, sister, all these children, and it looked like that.
It can get very, very complicated situation. I actually have 3 cases going right now that are similar situations. And what happens often in those is that you have to go out and hire what's called a professional heir search company. And they're expensive. And they will go out and dig up all the records. And I've had to do that on these 3 cases. And I actually had one case that I finished about a year ago. I think it was 72 heirs that we had to distribute money to. 72. It was quite a bit.
Yeah, that's a lot. So I'll get into my last scenario here,
Sure.
but then I want to get into some other points of how you transfer title and what happens from there. But let's just say there's no family. Somebody passes away and doesn't have a spouse, doesn't have any kids. No one can find any parents or siblings or anything of the sort.
Yeah, and occasionally that happens. Somebody passes away and has no family. And if that's the situation, eventually what's going to happen is any funds or monies that come into the estate is going to end up going to the state of California eventually.
Yep.
Yeah, it will.
Now title doesn't transfer automatically upon somebody's death, even if they're legally entitled to it, they don't own the house yet. So what do they need to do from there?
Well, in order to transfer title on the house after someone passes away, again, it depends on how title is held. If it's held in joint tenancy with a joint tenant's living, then that's an easy transfer. It's just one affidavit recorded with the county. However, if the person who passed away held title in their name only, no one else's name's on title, they're stuck with probate. You are.
Yeah, probate or possibly the newer petition
Yeah.
for term of succession.
You bring up a good
to
point.
primary
As
residence.
of April of this year, you're right, Brendan, there is what's called a petition to determine succession of the primary residence. And that's something that we have some other videos that we're getting into on that. It's a new probate procedure. It can be beneficial in certain circumstances.
Yeah, I think a lot of people don't realize how the pitfalls of it.
Yeah, and there are some pitfalls to it for
Oh,
sure.
Yeah, like
For sure.
being responsible for all the decedent's debts.
Yeah,
is one of them.
absolutely.
That's all taken care of in probate. So what if one heir wants the money, not the house? Say there's multiple heirs. One wants money and doesn't want the house.
And I assume some of the other heirs don't necessarily want to sell the house.
Perhaps so, or maybe they do want to sell the house. Maybe some prefer to keep the house, some don't want to. Is there a way if multiple heirs can they become co-owners?
Oh, sure.
Yeah.
Oh, yeah, absolutely. I mean, through probate, if basically if the house is not sold through probate, when you have the probate procedure, at the end of the probate, you're going to get an order that gets recorded with the county recorder, and that basically puts the house into all the heirs' names as tenants in common. They, if you have 5 heirs, each of them own an individual 1/5 of that house at the end of probate if the house is not sold.
Now, if there's a mortgage on that house, you're going to have to refi.
Yeah, most likely. Some people will just try to continue to pay the mortgage without telling the mortgage company, and some people get away with that, but really the right way to do it is to refinance that mortgage out of the deceased homeowner's name into the heirs' names. Yes.
Now, if one wants to cash out, usually that's when the house is sold. And that's
Right.
very, very common in probate that's the way that's done and the proceeds are split. But really one heir can buy the other out. It requires an agreement and sometimes
Sure.
financing.
Sure. Yeah,
Yeah.
absolutely. And that happens quite a bit where one heir wants to keep the house and is willing to buy the others out, and the others are agreeable to that. And that can all be done in probate. It's just documentation, getting the proper documentation done and filed with the court.
Now, disagreements can trigger court involvement, and I'm helping somebody right now who's trying to probate their father's estate, and he really wants his inheritance. His brother's living in the home and refuses to move. And there's ways that he's trying to entice his brother to move out without some costly legal action. But what can happen there? Because to my knowledge, one heir can't deny the other heir
Yeah.
their inheritance.
Now, depending on the situation, I mean, the court-appointed administrator or executor, they can start an eviction process against an heir or anyone else that's living in a probate home. They can do that. Or what can happen is you can go back to court and petition the court to basically, it's kind of like a partition action, where the court can say, yeah, you have to leave that house. It has to be sold. Or if the probate concludes and the property goes into the heirs, all the heirs' names, the heirs that want their money can file what's called a partition action in court. Expensive, costs a lot of money to do, but again, just as you said, an heir who wants to keep the house can't hold the other heirs who want their money. They can't stop them from getting their inheritance.
Yeah.
Yeah.
I've been advised by attorneys that sometimes an heir, say living in the house, doesn't want to sell and wants to stay there. And then they end up triggering costly legal action.
Yeah.
And the court is always going to side in favor of the other heirs because you
Absolutely.
can't deny that.
No.
So anyone watching this thinking that they can do that, it's not going to end up being good for you.
Mhm.
And some of the objections that I've heard from heirs who are living in the house and or maybe they're not living in the house, but think that they deserve the house is because they were making the mortgage payments.
Yeah. Or
Unfortunately.
they took care of mom and dad for a couple of years when they, were not in good health towards the end of their life, something like that.
Or mom and dad always said, well, you're going to get the house, but it's not actually in a will.
That's not in writing.
Yeah, that's a tough situation.
It is.
And I think you'll need some legal guidance on all of that.
Yeah, absolutely. If you get into a situation like that, that's a great example of when you really need a good attorney. Absolutely.
Oh yeah. Well, the part about somebody living in the house but they're making the mortgage payments. Well, what a lot of these heirs don't realize is that upon death, anyone living in the house is supposed to be paying fair market rent.
That's right.
To the estate.
That's
and
right.
often the mortgage payment is lower than fair market rent.
Yeah.
So the actual mortgage payment that you're making actually isn't sufficient to what you're supposed to be paying to the estate.
Yeah, and you're right. A lot of heirs living in the home after someone passes, paying them, they have no idea about that. They'd have and they could get stuck with a huge bill later on down the road.
Yeah. So I guess to conclude here, if there's no will, don't panic.
No.
But don't wing it either. I've helped families in this exact situation several times, and Bill has probated thousands of estates. So just reach out to us and we will help to consult you, and hopefully we can help you solve this problem. And of course, if you have a house to sell in probate, we'll handle that at a substantial reduction in fees for the cost of that.
Yep.
So please like and subscribe.